computer. In regards to COVID-19 emergency procedures and the administration of oaths via remote audio-video communication, this deposition of Elizabeth Sewell is being conducted remotely via Zoom. Today's date is February 9th, 2022. The time is approximately 11 o'clock a.m. Ms. Sewell, in what city are you located?
Homestead, Florida.
Thank you. The witness is located in Homestead, Florida. My name is Sylvia Evans. I'm located in Orlando, Florida. I'm administering the oath and reporting this deposition remotely. May I see your ID, please, Ms. Sewell? You need to put it right by the camera. There you go. Okay, thank you. Okay, would counsel state your appearance for the record and express your stipulation that the deposition and oath may take place remotely?
Dr. James Eric McDonough, I'm the pro se plaintiff, and I agree to the stipulation.
Sam Zeskind of Voice Sororita Healthman for the defendant, City of Homestead, and the witness, and we agree to the stipulation.
Thank you. Ms. Sewell, raise your right hand, please. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Okay, can you please state your name and occupation for the record?
Elizabeth Sewell, City Clerk.
Okay. All right, before we get started today, a few things I have to address. The Honorable Judge Rodriguez has made clear that speaking objections are improper. Mr. Zeskind, unless the question involves privileged materials, is expected that you won't state anything more than objective form. Further, as I know you'll object to nearly every one of my important questions, I grant you waiver from having to voice your objections in hopes we can get a clean transcript without a coached witness. Mr. Zeskind, if a question involves privilege, you should state what the privilege is, and you can instruct the witness not to answer. Also, Mr. Zeskind, refusal to share your video feed is considered disrespectful. At this time, you're respectfully requested to display your video feed. Failure to do such will be noted. Mr. Zeskind?
Yes, I'm under no obligation to share my video screen.
Ms. Sewell, this is not our first deposition, but I must quickly state a few instructions. If you don't hear or understand any of my questions, please ask me to repeat it, and I will be happy to do so. Please do not answer a question you don't understand, and please allow me to finish my question before you answer. If you need to take a break at any time, please let me know and we can pause the deposition. Unless Mr. Zeskind objects based on privilege or instructs you not to answer the question, you will need to provide an answer. Ms. Sewell, do you understand these points?
Yes.
Great. Let's get started here. I want to share this, we can call it Exhibit 1. I'd like to show you Request 1. This request is the subject of the lawsuit you're being deposed for today. I have my exhibits. Okay. Ms. Sewell, can you see this email?
Yes.
I'll scroll down. And you see this other email?
Yes.
Okay. Ms. Sewell, can you read the date of this email? I'm just highlighted it for you.
Tuesday, November 12th, 2019, 1:11 a.m.
Do you recall receiving this email, Ms. Sewell?
No.
No. Okay. Could you read the highlighted section of the email, Ms. Sewell?
Dear Elizabeth, I'm filing a formal record request under FS 119 for the exact same request I filed in October 12, 2015. I hereby file a record request for all documentation and financial records related to the city's decision to use the law firm of Weiss, Sororita, Healthman, Cole, and Behrman to defend Officer Alejandro Maguido in Miami-Dade County, case number 15-08342CA08.
Thank you, Ms. Sewell. Was this email in writing?
Yes,
And did this email identify the public records request?
yes,
Do you recall handling this request, Ms. Sewell?
no,
Let me scroll up here just for a second. This is your response to me. Could you read the highlighted response, Ms. Sewell?
Good morning, Mr. McDonough. This email acknowledges receipt of your public record request dated November 12, 2019.
And do you recall sending this email, Ms. Sewell?
I don't recall, I'm seeing it now.
Okay. And in this request, do you know if you handle the request other than just receiving my request and forwarding it to other departments?
Check the form.
It was forwarded to the other department where the record resides.
Okay.
That's
But,
a normal process.
all right. Let me back up for a second. Did you ever speak to anyone about this request, Ms. Sewell?
I do not recall.
Were you ever told anything specific or instructed on how to handle this request?
No,
So is it fair to say that anything you did in responding to this request was done on your own volition?
I don't understand your question, Mr. McDonough.
Okay, let me try to rephrase this. Any activity or actions you did responding to this request, did you do it on your own? Or would you have done it on your own?
I can't recall.
You can't recall.
No,
So you're not sure if you spoke with anybody about this request then?
the normal process is we forward it to the department where the records reside. Because it may have been involved in the litigation, the city attorney would probably review the responses. They may have helped in drafting the response, but I'm not sure.
Okay. Let me stop sharing this for a second. I'd like to show you a letter that you sent me, and we can call this Exhibit 2. Can you see this letter, Ms. Sewell?
I can see a portion of it, yes.
I'll scroll down for you. Is that your signature at the bottom of the letter, Ms. Sewell?
Yes, it is.
Did you draft this letter, Ms. Sewell?
I believe this was crafted by the attorneys.
Okay. Do you know how you would have gotten a copy of this letter?
I am not sure. I mean, it
Okay.
could have been emailed to us. It could have been dictated to us. I'm not sure. I don't remember.
Okay. I mean, this is a fairly extensive letter with a lot of citations to law and court hearings. Do you think that would have been dictated to you?
I believe it was. Or it could have been emailed. I'm not sure, Mr. McDonough. This has been a while ago.
Okay. Can you read the date of the letter for us?
November 19, 2019.
And you're not sure if you drafted this or if the attorney drafted it?
I believe it was drafted by the attorney is what I said.
Okay.
I'm saying I'm not sure how it got to me.
Okay. Would you know which attorney drafted this?
No, I don't.
You don't, okay. Ms. Sewell, I filed this lawsuit on November 27th, 2019. Ms. Sewell, would you agree that November 27th, 2019 is 5 or more business days after November 19th, 2019, when you sent me this letter? I can show you a calendar if that helps.
I'm not sure what you're asking.
Is November 27th 5 or more business days after November 19th?
Yes,
Yes, okay. So then you also agree that November 27th is more than 5 business days after the request was submitted on November 12th. Is that correct?
yes,
Okay. I want to scroll down to the bottom of this letter. Ms. Sewell, do you see that footnote?
yes.
Could you read the footnote for us?
In addition, during the September 12, 2016 hearing in case number 16-12412 relating to your original submission of this request, your counsel stated on the record that you were not asking for any correspondence between Officer Maguido and the law firm of Weiss, Sirota, Helfman, Cole, and Bierman. See transcript page 23, lines 1 through 4. As such, the city does not read your current request to include a request for the July 8, 2015 letter from Eric Stetton to Officer Maguido, identified as record 5 in case number 16-12412.
Thank you, Ms. Sewell. So was this July 8th letter withheld from production?
I don't know, Mr. McDonough. Whatever records was given to us was given to you.
Okay, but this footnote you just read stated that y'all don't consider my request to be asking for that record, for that letter. Is that correct?
Check the form.
As I said, this was drafted by the city attorney.
Okay. Are there any exemptions claimed for withholding this letter?
I don't know.
Do you see any exemptions asserted here?
I think further up in the letter, there's something. There seems to be some sort of exemption in the middle of the letter.
Is that exemption for the July 8th, 2015 letter?
I don't know.
Can you read this and see if you see any claimed exemptions for the July 8th letter?
No.
So you don't see any exemptions exerted for the July 8th letter, is that correct?
According to this letter, no.
Okay. And do you know why my request was interpreted not to include this letter?
No.
Do you know who would know the answer to these questions, Ms. Sewell?
No, I don't.
Okay. All right, let me stop sharing this. I'd like to show you something that Mr. Zeskine filed here in my first records lawsuit, the case number 16-12412, which was based on identical records request here. It also tracks the response in your letter. We can call this Exhibit 3. Let me share this. Do you see this, Ms. Sewell?
Yes.
This is the privilege log that Zeskine filed with the court in the earlier case, showing only 5 documents are responsive and that all 5 are exempt. Do you see the entry number 5 there, Ms. Sewell?
Yes.
And that's the letter from Eric Stetton to Officer Maguido.
That's what it states here, yes.
And can you read the claimed exemptions for that letter?
119.071, paren 1, paren D, paren 1, Florida statutes, 768.28, paren 16, paren D, Florida statutes, 90.502, Florida statutes.
Okay, and do you know what those exemptions are by
No,
chance?
no.
No, okay. Do you know who determined that only 5 records were responsive to the first request?
No,
Is the 5th document here, the July 8th, 2015 letter from Eric Stetton to Officer Merguido, the same July 8th, 2015 letter referenced in the footnote of your letter to me?
I don't know.
Don't know.
I did not draft the letter.
Do you think there would be more than one July 2008 letter
I
from
don't-
Stetton to Merguido?
I don't
Like
know.
the form.
If there was more than one letter, then would you assume that it would be noted that there were 2 letters?
Like the
I
form.
don't know.
Okay, so we do agree that this 5th document, this letter was withheld, is exempt in the first case?
I don't know. I see here an exemption. Yes, I don't know what it's pertaining to, except that it's the July 8th letter.
Okay, but there are exemptions claimed in this privilege log that was provided, correct?
Yes.
Okay, let's go back to request 1 for a second. And let me scroll down here for a little bit. So this is part of my email request for request 1. Could you read the highlighted section right there for us, Ms. Sewell?
I want all the records which were then claimed to be exempt or otherwise protected from disclosure.
So you agree that I was explicitly requesting any records that were initially claimed to be exempt or otherwise protected from disclosure. Is that correct?
That's what the statement says.
Okay. In light of my request explicitly asking for all records which were claimed to be exempt or otherwise protected from disclosure, do you know why this record was not provided to me?
No,
Do you know how it was determined that I was not seeking this letter?
no,
Do you feel that withholding that letter is a reasonable interpretation of request 1?
I don't know.
You don't know?
No,
Do you interpret request 1 to not be seeking that letter?
I don't know.
You don't know. If a requester explicitly asks for something, is there a reason other than it being exempt why it would not be provided to them?
I was not involved in preparing the records. I don't know.
Okay. Let's go back. Oops. Let me see if I can share this again. Oh, messed up. 1 second. Please bear with me. Okay. I want to focus back on your footnote for a second here, where it says, in addition, during the September 12, 2016 hearing in case 16-12-412, your counsel stated on the record that you were not asking for any correspondence between Officer Merguido and the law firm of Weiss, Sirota, Helfman, Cole, and Bierman. See transcript page 23, lines 1 through 4. As such, the city does not read your current request to include a request for the July 8th letter from Eric Stetton to Officer Merguido. Do you know why something my attorney said in 2016 would override the specific instructions from my request filed in 2019?
No,
Ms. Sewell, was my request liberally interpreted?
I don't know.
I specifically asked for something and it wasn't given to me. Would you agree that that's not a liberal interpretation of my request?
Check the form.
I gave you everything that was given to me, Mr. McDonough.
I appreciate your explanation, but could you provide a yes or no for that, Ms. Sewell?
I don't know.
You don't know. Okay. All right, I'd like to show you another exhibit. We can call this exhibit 4. This is my response, clarifying and broadening my request. Do you see this email, Ms. Sewell?
Yes, I do.
Do you remember receiving this email, Ms. Sewell?
I don't recall receiving it, but I see it here on the screen.
Okay. Could you please read this email into the record from Dear Elizabeth to regards?
Dear Elizabeth, I hope you're having a wonderful day. Thank you for your responses to my November 12, 2019 record request. However, I am perplexed at your response and the interpretations you have made. Once again, I'm requesting immediate production of all records which were responsive at the time. I originally filed the request in 2015. This means all related records ad infinitum. Apparently, your attorney, Sam Zeskind, does not understand what all means unless I add the term ad infinitum. Zeskind also basically stated this on the record at the September 12, 2016 hearing. For the record, ad infinitum does not modify the term all. If the city has records in its possession that are in any way related to the defense of or decision to defend Maguido, when he was being sued in a civil case in his individual capacity, and they were responsive and available on October 12, 2015, I want them, period. This means any and all responsive records related to the defense of and defense to defend Maguido in this civil case ad infinitum. Additionally, while Maguido may have a confidentiality privilege with the attorneys about the civil case at issue, the city and Maguido and the city and the attorney do not. I expect all the responsive records requested, which are in the possession of the city, not its contractors, to be provided fully and completely by the end of the week, and any withheld or redacted material to state the specific reason for withholding and redaction. Regards.
Thank you, Ms. Sewell. Did you respond to this email clarification, Ms. Sewell?
I don't recall.
And so you wouldn't know if anyone else responded to this email either, would you?
I don't know.
Do you know why you wouldn't respond to this email, Ms. Sewell?
I don't recall.
When you process a public records request and the requester asserts that not all records were given to them and clarifies their request, do you generally respond to those clarifications?
If it involves a lawsuit, we will send it to the city attorney and they may provide a response.
When this records request was filed, it did not involve a lawsuit, Ms. Sewell.
Check the form.
Can you state why you failed to respond to this email?
If my
Check the
staff
form.
was responding to you, then that person would have been the person to respond. I do not recall.
But this email was sent directly to you, Ms. Sewell, and I never received a response. Can you explain that?
No,
Would you say that you dropped the ball in not responding to this clarification?
Check the form. Dr. McDonough, can you scroll up? What's the date on this email?
Sure.
I just can't see the top of it.
November 19th.
Thank you.
Ms. Sewell, would you say your failure to respond to this email was dropping the ball?
Objection to form.
I don't think I dropped the ball. I don't recall.
But you have admitted to dropping the ball in other of my requests. Is that correct?
Object to form.
Ms. Sewell, have you ever testified to dropping the ball in any of my requests?
Yes,
Yes, you have. Okay, thank you. Ms. Sewell, in light of the explicit wording of request 1, which we have already gone over, and the wording of my clarification, did you feel it was proper to continue to withhold the July 8th, 2015 letter from me?
I did not withhold anything from you. Everything that was provided to this office was provided to you. I did not withhold anything.
The July 8th letter was noted as being responsive and withheld from production.
I
Do you
did
feel
not,
it was proper? Let me finish. Do you feel it was proper to withhold that letter?
I did not withhold the letter from you. I cannot respond to that.
You're the custodian of records for the city of Homestead, correct?
If the record is in my possession, it would be provided to you. It was not in my possession. I did not withhold it from you.
But it was withheld from me. Do you believe?
I did not withhold it from you.
I understand that, Ms. Sewell. I'm not saying that you withheld it. Somebody withheld it from you, so it ended up being withheld from me.
I would not
Objection
have
to
known.
form.
Do you feel the withholding of that letter was appropriate?
Objection to form.
I don't have a response for that, Mr. McDonough. I don't know.
How long have you been responding to public records requests, Ms. Sewell?
A few years.
For more than a decade, is that correct?
Yes,
Okay. So you have a lot of experience with responding to public records, correct?
I have experience.
In your understanding, is it proper to withhold a responsive record without citing an exemption?
I was not responsible. I don't know.
That's not my question, Ms. Sewell. Ms. Sewell, in your experience as the custodian of records with over a decade of responding to public records requests, is it proper to withhold a responsive record without citing an exemption?
Objection to form.
I answered you, Mr. McDonough. That's my answer. I don't know.
You don't know if it's proper to withhold without citing an exemption.
I answered you.
You're being very evasive, Ms. Sewell. It's a simple yes or no. Yes or no, is it proper to withhold a responsive record without citing an exemption?
I do not know.
So you're testifying here today that as the custodian of records with more than a decade of experience responding to public records, you do not know if it's proper to withhold a record without citing an exemption?
I gave you my response. I don't know what you want from me.
I want to hear you say, yes, it's proper, or no, it's not proper.
I said, I don't know. That's my answer.
Okay. All right, I'd like to show you another exhibit. We can call this exhibit 5. This is request B. It's the request that was filed by Mr. Jason Jensen. Do you see this email, Ms. Sewell?
Yes.
Okay. Could you read the highlighted section of the email for us, Ms. Sewell?
I also hereby request the same information. This is absolutely no way all of records for all documentation and financial records related to the city's decision to use the law firm of Weiss, Sirota, Helfman, Cole, and Bierman to defend Officer Alejandro Maguido in Miami-Dade County, case number 15-08342 CA08, are privileged, exempt, or otherwise protected from disclosure. Well, the case, highlighted, sorry.
That's fine. You're doing great. I want to scroll down so you can see. Hopefully I can be able to get all the email on here. I guess it's not going to happen. Okay, you can see Dear Elizabeth, like right above the highlight, Dear Elizabeth is a frequent visitor to Homestead, Florida.
No, it does not say Dear Elizabeth, it says Dear Patricia.
Dear Patricia, I'm sorry, I misspoke. I just want to make sure that you see that. I don't want to hide anything from you. I want you to be able to see as much of this. Well, actually, you know what? Maybe I can minify this a little bit and it'll make it easier. Let me see. Okay, so you can see that's the bottom of the email. There's nothing else there. Ms. Sewell, can you take a minute to review this document? And after doing so, I want to know if you agree that the quoted section up here, it's in quotation marks. I'll highlight just that. Would you agree that the quoted section you just read was describing the records requested by Mr. Jensen?
No, I don't know what Mr. Jensen is really asking for.
I'm also going to object to form and just point out as an objection.
Objection to form. That's nice, Mr. Zeskine. You can stop or we'll go right back in front of Rodriguez and you explain to him.
I will finish the objection, just that you're getting outside.
He told you no long-winded speaking objections, Mr. Zeskine. Are you going to violate the judge's order?
Dr. McDonough, you're going outside of what's relevant to this case and into requests that have been the subject of other litigation, which you've agreed.
Mr. Zeskine, that is not what's going on here.
Email dated January.
Mr. Zeskine, that is not what's going on here. If you want to call it this deposition, we can go back in front of Judge Rodriguez and you can explain it to him, and I'll tell you exactly.
I'm not halting the deposition. I'm just putting on the record that this is a request that's been the subject of other litigation.
All right, you made your objection. Nice. That's noted. I appreciate it.
Ms. Sewell's already been deposed in that lawsuit. And so you've agreed that you weren't going to do discovery for your other cases.
This is not discovery for another case. This is discovery for this case, Mr. Zeskine. Ms. Sewell, the highlighted section that's in quotation marks, do you agree that this is verbatim language, the same as the request, first request here that we were discussing earlier?
I don't know.
Okay, let me show you the first request. Do you see that highlighted section there, Ms. Sewell?
It appears to be.
Can you read the highlighted section for us, Ms. Sewell?
All documentation and financial records related to the city's decision to use the law firm of Weiss, Sirota, Helfman, Cole, and Behrman to defend Officer Alejandro Maguido in Miami-Dade County, case number 15-08342 CA08.
Okay. Now I'll go back to Mr. Jensen's request.
It appears to be.
So we agree that this is identical language.
Yes.
Okay. I'd like to show you another exhibit. We can call this Exhibit 6. Do you see this, Ms. Sewell?
Yes.
And would you agree this is an email of you responding to Mr. Jensen?
Yes.
Do you recognize this email, Ms. Sewell?
No, but I see it now. It's been a while.
Okay, so you don't recall sending this to Mr. Jensen?
No.
Okay. All right, I'd like to show you another exhibit. We'll call it Exhibit 7. Let me make this a little bit bigger for you. This is the invoice that was attached to your email to Mr. Jensen.
Object to form her email to Mr. Jensen?
Yes, this email right here. Mr. Jensen, good afternoon, Mr. Jensen, attaches an invoice reflecting the charges associated with production of said records. As soon as payment is received, the records will be provided. You see the little at the bottom invoice, Jason Jensen?
Yes.
This,
okay.
this is the email Ms. Sewell forwarded to Mr. Jensen that had an attachment. this is the attachment to that email.
Okay.
Okay. Do you recognize this invoice, Ms. Sewell?
I did not prepare the invoice, I don't believe.
I won't let me highlight this whole thing. Ms. Sewell, the section in the middle that I'm trying to highlight, but it won't let me do it all in one. Can you read that for the record for us?
I can barely see it, but I will try.
Oh, I'm sorry. I'll blow it up for you.
Public records requests asking for all documentation and financial records related to the city's decision to use the law firm of Weiss, Sirota, Helfman, Cole, and Bierman to defend Officer Alejandro Maguido in Miami-Dade County, case number 15-08342, CA08.
Would you agree that this is verbatim and identical to the language of the first request and Mr. Jensen's request?
Yes.
Okay. Let's see if I can keep this somewhat large, but okay. Can you tell us what the charges are for in this invoice, Ms. Sewell?
It says 122 pages at 15 cents each.
So that's a copy in charge, is that correct?
Yes,
And it's for 122 pages, is that correct?
that's what the invoice says, yes.
Ms. Sewell, would you agree that 122 is more than 5?
What?
Math, is 122 more than 5?
Yes,
Okay. Can you explain why the city did not provide or mention any of the 5 records, which I was told were responsive to my request to Mr. Jensen, who filed an
I don't-
identical request?
I don't know.
Can you explain why the 122 pages of records offered to Mr. Jensen were withheld from me?
I don't know.
Objection to form.
Can you explain why these 122 records weren't even disclosed to exist to my request?
Objection to form.
I don't know.
But you agree that Mr. Jensen and I submitted identical requests, correct?
Objection to form.
According to the information presented, yes.
Ms. Sewell, is the production of public records in Homestead just a free-for-all?
I don't know what you're talking about, Mr. McDonough.
Does the city respond differently to different requesters who request
Not
identical
that I-
information?
Not that I am aware of.
But the city did do it this time, is that correct?
I don't know.
Objection.
As
You
I
don't know?
said, I did not prepare the records. I
Okay,
gave you what was given to me to give to you.
okay, no need for attitude, Ms. Sewell. I'm trying to be as nice to you as possible here. I
don't
have questions I need to
attitude,
ask.
Mr. McDonough. I'm answering your questions. You're asking me the same question over and over, and I keep giving you the same answers because that's the answer I have.
I'm not asking you the same question over and over, Ms. Sewell. I'm asking you different questions. Do you think that all my questions are the same, Ms. Sewell?
You keep asking, the process is the same. You send me the record request, we send it to the department and has the record. They provide us the record and we provide it to you. I don't know what decisions are made, where they're made, when they are made. You're asking me something I have no knowledge of.
Okay. We showed you the city's privilege log. We showed you the letter you sent responding to me. 5 records were identified to me as being responsive to my request. We showed you Mr. Jensen's request, which was identical. We showed you your response to Mr. Jensen, and we show you Mr. Jensen's invoice, which provided 122 pages of records. Ms.
As I
Sewell,
said-
can you please explain why 2 completely different sets of records get considered as responsive to 2 requesters filing identical requests?
I do
Objection to
not
form.
know. The record is provided to me and I provide it to you. I do not determine what you get and what you do not get. That's determined wherever the department is. It was not determined by me. I do not know.
Ms. Sewell, do you think it's proper that me and Mr. Jensen got two different sets of records to identical requests?
I do
That's
not
in the
know.
form.
You don't know if you think it's proper or not?
I do not know.
Would you like to consider it? I mean, again, your testimony here today is the custodian of records for the city of Homestead is you don't know if it's proper or improper to send two different sets of requests to two requesters asking for the same records.
Check the form.
I provide to you the records provided to me. Whatever was provided to me in response to your request and whatever was provided to Mr. Jensen in his request, that's what was given to each of you.
Ms. Sewell, me and Mr. Jensen filed identical requests, and I got told there were 5 records. He got told there was 122 records. Would you say that someone in the city of Homestead
won't
dropped
say
the
it was
ball on these
120.
requests?
I don't think it was 122 records, 122 pages.
122 pages.
Objection to form. Dr. McDonough, is it your position that you didn't receive those 122 pages?
You gave me them recently, but you didn't they weren't provided a year or two ago when I filed the request.
You're saying that they weren't provided to you and you didn't admit in the other pending lawsuit having
They were never
received
given
those
to
records
me.
for
They were
the-
never given to me. They were given to Mr. Jensen.
You didn't admit to paying the cost of those records and picking them
I
up?
went and provided the cost for Mr. Jensen. Records were never provided to me, Mr. Zeskind. You can try to play all the little Weasley games you want to play, but I'm not the one on deposition and being deposed here. I'm not the one testifying here, but those records were never given to me, Mr. Zeskind, and you know that. You were told that by Miss Bailey on the July 31st, 2017 hearing. Do you remember that? Didn't think you'd want to respond. So Ms. Sewell, the fact that me and Mr. Jensen filed identical requests, but get different records, would you agree that that's dropping the ball?
Objection to form.
I didn't drop the ball.
Not you, Ms. Sewell. Did somebody drop the ball here?
It wasn't me. You're asking me something
No,
I
I'm
have
not.
no knowledge of.
I'm asking you, do you think that someone dropped the ball?
No, I do not know what anybody has done. I give you what's given to me, Mr. McDonough. I don't go searching to figure out if you got 100 records and he got 200 records. Whatever is given to me is given to you.
Okay. Would you agree it's improper to not give me and Mr. Jensen the same records? Is that correct?
Objection to form.
I gave you my answer. I do not know what you're asking.
I'm asking, in your opinion, do you think it's proper or that it was proper that me and Mr. Jensen got two different records for identical requests?
I don't have an opinion, Mr. McDonough.
You don't have an
I'm
opinion.
an actual
Okay.
witness.
And you have no idea who worked on these requests.
No, I don't.
Is there any accountability for public records in your office, Ms. Sewell?
Whatever we provide, whatever's provided to us, we are accountable to providing to you, and that's what we did. That's
Okay.
the accountability.
Is there other accountability within inside the city of Homestead outside of your office?
I don't
Objection to
know.
form.
I assume that they're doing what is required, but I don't talk to them about it.
Ms. Sewell, do you
Not
accept any
especially-
responsibility for my records requests which have been improperly handled?
Objection to form.
No, I don't accept any responsibility. It's not my responsibility.
Even when you admitted to you dropping the ball
I'm
in responding to my
responsible
records
Objection
for-
to
request, you have no
form.
responsibility for that?
Yes, that I'm responsible for, but I'm not responsible for anybody else's.
Okay. Ms. Sewell, are you aware that the city has repeatedly claimed that I have filed my request in lawsuits for an improper purpose?
I'm not sure.
Ms. Sewell, do you think that I've filed any of my requests for an improper purpose?
Objection to form.
You file your request, we send it to the department where the record is, they send it back and we respond to you.
That's not my question, Ms. Sewell. Do you
That's
understand
my
my question?
answer. That's my answer.
So you're refusing to answer the question?
I answered the question.
No,
I
you did
gave
not,
you an
Ms. Sewell.
answer. That's
Objection.
my
She
answer.
can't testify. Excuse me. She can't testify to your mindset, Dr. McDonough, or your intent.
I don't know what you're doing.
I'm not asking her about my mindset or intent, Mr. Seskine.
You just asked if she thought that you submitted your request to maintain your lawsuits for an improper purpose. You're asking her to testify to that. So I raised that objection.
Okay. Ms. Sewell, do you know of anybody in the city that would have knowledge of whether I have filed for an improper purpose or not?
No,
No. Do you have any evidence that I've ever filed a public records request for an improper purpose?
you file your request. I don't know if it's for improper purpose or not. We don't deal with it on that level. We send it to where the record resides and we provide it back to you. Whatever response we get from the department, where the record is.
Ms. Sewell, has the city, to your knowledge, ever unlawfully refused to provide me with public records?
Not that I'm aware of. Other than the situation where I forgot to provide you something. That's the only incident that I'm aware of. And it was not intentional on my part.
I appreciate that offer, Ms. Sewell. In that other lawsuit where you admitted to dropping the ball and unlawfully failing to respond to my request, the court also determined the other two requests were unlawfully responded to as well.
I did not handle those.
Ms. Sewell, do you think that 3 unlawful refusals would constitute a pattern? Would you think that to be a pattern?
Objection to form.
I don't know. I don't think so.
Ms. Sewell, in your opinion, how many violations of the law would it take for there to be a pattern?
Objection to form. She's not here to testify as to her opinion.
Stop saying anything more than objective form, Mr. Zeskine. That's a speaking objection. It's improper.
I have no opinion.
What is your testimony that you have in the past unlawfully refused to comply with my records request, correct?
Not unlawfully, it was an oversight on my part because of the work duties that I had in my office at the time.
The court found that to be unlawful, Ms. Sewell. Are you saying that the court is incorrect there?
I did not say
Objection to
that.
form.
I just explained why the ball was dropped on that one particular request. And I'm not sure why we're going over this over and over and over when that was another case.
Because my requests aren't being properly replied to, and I have an injunction because of the pattern of city and yours unlawful refusal to reply to my public record request, Ms. Sewell. That's
I have
why.
not unlawfully, from whatever you said, that's not true. Okay?
So you're saying the court
Where
was
records
wrong.
are-
You're saying the
I
court.
did- No, I did not. You're twisting my words and I need you to stop.
Objection to form. You're going,
badgering
now
me.
you're discussing another litigation.
Yes.
All
And
right.
you're badgering me and you're trying to
Improper.
trip me up and I'm not going to go there with you. So,
That other case, by the way, which is on appeal.
Yeah, I know it's on appeal for the stuff I didn't get. The court did unlawfully find that all 3 requests were unlawfully
the
delayed.
court is wrong on that too, right? The court is wrong.
All right, let's move on. Let's move on.
Ms. Sewell, your testimony is the court was wrong.
Let's move on.
I said, no, you said that the court unlawfully did something and I'm saying to you, so the court is wrong when it comes to your stuff, but it's not wrong when it comes to my stuff.
I never said the court did anything unlawful. I said the
Okay.
court found, let me finish. I said the court found the response from the city and you to be unlawful, Ms. Sewell.
Okay, Mr. McDonough. Whatever you say.
I didn't understand your question.
All right,
your response.
let's ask questions. Let's
Mr.
get back to the
Zeskine,
deposition.
you can ask whatever questions you want when you're taking a deposition. I'm taking the deposition. I ask the questions I want.
You're not
Thank you very
asking a
much.
question right now. You're arguing with the witness about what happened in another case.
Because you and the witness are sitting there trying to argue and she's being evasive and refusing to answer my questions.
I am not evasive. I'm telling you what I don't know. You don't like the response because you think I know, but I don't. And you're badgering me for something I have no knowledge of. I have explained to you over and over the process, and you refuse to understand. So you keep doing this over and over. So we're going to do this over and over.
We'll do this over and over, and I'll drag you back in front of the court, and the judge will tell you to sit down and answer my questions if that's what you really want, Miss Sewell.
Whatever you want to do, Mr. McDonough, I can only respond to what I know. If I don't know, I don't know.
Miss Sewell,
All right, are you going to ask her questions again related to this lawsuit, or are you going to continue to go back and forth and argue? If it's just argument, we'll just end it. If you have questions related to this lawsuit, then
I
ask them.
have questions if you would stop interrupting me, sir. Sylvia, can you know for the record that Mr. Zeskine continues to make speaking objections, which he was told not to do? Thank you. Ms. Sewell, are you aware that an unknowing violation of the Public Records Act has a fine and a penalty with it?
No, I don't know.
You don't know that.
Mhm.
And it's your testimony that because your failure to comply with my records request was unintentional, that therefore it was not unlawful?
I did not say that. All I said it was unintentional. And what I said was there was mitigating circumstances that caused that. That's all I said. I never said it was lawful or unlawful. I did not. You're trying to twist my words.
What do you believe that your response was lawful?
Objection to form. You're asking her questions about her response in another lawsuit that's been concluded through trial and is currently on appeal. We're not answering any more questions about that other lawsuit in this deposition. If you have questions about the public records request or the subject of this case, ask them. But if you're only going to continue to go back and forth with the witness about another case that's already concluded and is on appeal, we will end the deposition.
Mr. Zeskine, are you aware that these other cases were cited in this case as part of me elucidating the city's pattern of unlawful refusals?
Are you aware of the only one other request that's cited in your claim for injunctive relief, and it's not the requests that are the subject of that other litigation?
Are you aware that other litigation came after this?
It's not in your complaint. I don't know what to tell you.
Okay. Ms. Sewell, I need to address something with you real quick. Is it true that when I send you correspondence, I always sign off as Dr. James Eric McDonough?
Yes,
Have I ever signed any other way to your knowledge?
no,
Ms. Sewell, are you aware that Judge Asharte scolded the city attorneys for disrespectfully addressing me as Mr. and not Doctor?
Objection to form. Judge Asharte is not even the judge in this case. Now you're referring to the other case again. If you don't have questions regarding this case, we'll end the deposition.
I got plenty of questions, Mr. Zeskine. If you want to end the case, we can go back in front of Rodriguez. Just do it. Say you want to walk away and we'll do it. We'll go back in front of Judge Rodriguez. I'm fine with that.
You're asking her about something that Judge Asharte said in another case. Move on.
Don't tell me how to do my deposition, sir. Do you understand that? When you do a deposition, you can do it however you want. Objective form all you want. Ms. Sewell, is there a reason that you absolutely refuse to refer to me as doctor?
no. I call you like I call everybody else, Mr. You're another person to me, just another human being, Mr. McDonough.
It's
I call
Dr.
everybody else by Mr.
It's Dr. McDonough, Ms. Sewell. Could
I
you
said
please refer to me
Mr.
as Dr.
McDonough.
McDonough in the future and not
Miss-
disrespect me?
Mr.
I work for my
McDonough.
title.
Mr. McDonough,
Dr. McDonough, please.
Mr. McDonough,
Okay, so you refuse to address me by my title.
as far as I know, you're Mr. McDonough.
Okay. Ms. Sewell, why do you insist on disrespecting me?
I don't disrespect you. I don't consider it disrespecting you. I call you Mr. There is a title, Mr.
Ms. Sewell, can you stop turning away from the camera, please?
Sure. You want all of my attention? Here it is.
I want all of your attention here. You continue to take your attention to other places. Ms. Sewell, could your refusal to address me as doctor be due to your subconscious hatred of me?
Objection.
I don't hate you, but
But you think I'm a mean person.
no, I don't.
You testified in the past that I was a mean person.
Objection.
But today I don't think you're mean.
So you changed your opinion of me.
Yes, I think you're a very nice man.
Okay, you understand that you're under testimony, right, Ms. Sewell?
Yes. Yes.
And do I intimidate you, Ms. Sewell?
No, not at all.
Do I scare you, Ms. Sewell?
No, not at all.
Do you have any fear of me, Ms. Sewell?
No, but you do yell at me.
Have I ever threatened you, Ms. Sewell?
Your yelling is considered a threat.
Have I ever threatened harm against you, Ms. Sewell?
No, I don't think so.
No, you don't think so, or no, I have not?
No, I don't think so. That's my answer. You're not going to change my answer.
Well, you changed your answer, Ms. Sewell.
Yep, that's my privilege.
Okay. Can I ask what it was that's happened in the last 6 or 8 months or a year that's made you go from thinking I was a mean person to thinking I was a nice person?
Well, I haven't seen a whole lot of you lately.
So if I
You
hide in
only
the back,
meet in these depositions. We haven't seen each other like you used to come in to City Hall all the time, yelling and screaming.
when did I come into City Hall yelling and screaming?
You have on occasion.
Did I come into City Hall yelling and screaming? Is that why you filed a police report against me, Ms. Sewell?
Objection to form.
There we go. Is that about this public record request?
Actually, it's very related because I was questioning you about an invoice for an identical request. So yes, I think it's
She's already given her testimony and deposition regarding that police report. Not going to revisit.
Mr. Zeskine, you created this problem, sir. You started off saying we could consolidate the cases for discovery purposes. Then you went and argued that I have to do them all separately. So I have to ask the question if it's relevant to the case in every deposition, not just one time. Do you understand that, sir?
It's not an accurate representation of what's occurred, but the bottom line is
What's inaccurate about that, Mr. Zeskine?
she has given her
No, Mr.
testimony.
Zeskine, you say it's inaccurate. What is inaccurate about that
You
representation?
don't need to ask her those same questions again. She's given her testimony regarding
So,
the police
are you
report,
saying that
which is not relevant to this litigation?
Yes, it is. It's very relevant to this litigation. My requests are not being properly dealt with. She sent me a letter. She withheld records. She can't identify who withheld the records if it wasn't her. I believe it's her hatred and animosity against me for why it's being withheld. So it's absolutely relevant. Is it your position that it's not relevant? And are you going to stop me from continuing to ask these questions? And we'll just call a deposition today and we'll go in front of Judge Rodriguez and see if he agrees that I can ask it or not.
I objected and said it wasn't relevant.
And saying it's not relevant is a speaking objection. Is that correct, sir? So, Ms. Sylvia, can we again note that Mr. Zeskine is not complying with the judge's order to not make speaking objections? Ms. Sewell, how long have you been employed by the city of Homestead?
A little over 11 years.
And do you know what your start date was?
May 10th, 2010.
Okay. And your current title is city clerk?
Yes,
Was that your title when you started?
yes,
Have you worked as the city clerk anywhere else?
yes.
Could you tell us where?
Florida City and town of Golden Beach.
Okay. So it's fair to say that you've been a city clerk for well more than a decade.
Yes,
What's your educational background, Ms. Sewell?
I have my certification as a city clerk.
Is that a bachelor's degree, a master's degree, just a certificate?
It's a certificate. I
And do you-
also have a master's degree in public administration.
Okay, so you're a very intelligent, educated woman.
I don't know if you'll say that, but I have an education.
Having a master's degree probably puts you above 95% of the population in terms of education. So I would think you're a very educated lady.
Okay.
As a city clerk, you're the custodian of records for the city of Homestead, correct?
Yes,
As the city custodian of records, are you the primary person responsible for public records requests submitted to the city of Homestead?
yes.
So the buck stops with you.
Section 4.
No, it does not, because all the records do not reside in my office. They reside in other places in the city. I have to go to get it from there. Carry back to the same process. I'm explaining it again. Because
Have you always had to respond to public records requests as part of your employment as the city clerk?
Yes,
Have you received training on responding to public records requests?
yes.
Can you describe any of this training?
Yes. That public records are to be made available to the public. And there are things that are exempt, confidential, and those things are withheld.
And if it's not exempt, it's to be provided to the public?
I guess, yes.
So when I request records and they're not exempt, but they're not provided, would you agree that that's improper?
I did not withhold the records from you. You keep
That's
accusing me.
not the question, Ms. Sewell. Do you
I am-
understand my questions, Ms. Sewell?
I understand that you're asking me if something is withheld. I did not withhold it. You keep accusing me of withholding records.
I'm asking you a general question, Ms. Sewell, not specifically about any request. The general question is, if a requester files a request for public records, and there's records that are responsive to that request, and they are not exempt, would it be proper for any reason to withhold those?
There must be an exemption why they were withheld.
So if no
I don't-
exemptions claimed, it's improper to withhold a record. Is that correct?
Section of form.
I answered you.
No, you did not, Ms. Sewell. Let me restate the question for you one more time. If someone files a records request and there's a responsive record and there's no exemption, is it proper to withhold that record?
Section of form.
I can only testify to the records that were provided to you.
That is not my question, Ms. Sewell. Sylvia, will you note that the witness is refusing to answer my questions?
Those questions were asked and answered earlier in the deposition.
She still has not answered this question, Mr. Zeskine. It's a yes or no question. She can explain all she wants. Ms. Sewell, you can explain your answers all you want, but I need a yes or no. If someone files a request and there's a responsive record
I don't know.
and there's no exemption,
I
is
don't
it proper to
know.
withhold it?
I don't know. You have an answer.
You
I don't
just-
know.
You just testified a minute ago that when someone files requests for records, that you give
I
them
did-
records unless they're exempt.
I did not.
So are you
You asked
confused
me
with your own
what-
testimony?
You asked me what I learned. I told you what I learned. That's it.
Okay, so you agree that you learned that if there's a record that's responsive and it's not exempt, it needs to be produced. Did you learn that?
I learned that public records are provided to the public. That's what I learned.
And they have to always be
Unless they're
provided to the
exempt.
public unless they're
Unless they're
exempt. Is that
exempt and
correct?
confidential.
Unless they're exempt or confidential, they have to be provided. Is that correct?
Yes,
So withholding a record without providing an exemption is improper. Is that correct?
it could be confidential.
If you're withholding a record and it's not confidential or exempt, is that proper?
Section of form.
We're going around here in circles.
Because you refuse to answer the question, Ms.
I'm
Sewell.
answering your question.
Mr. Zeskine, can you instruct the witness to answer the question, please?
She's answered the question. She
No,
said,
she
I
has
don't know.
not. It's a yes or no question.
She
and she has
said,
not
I don't
provided a
know.
yes or no.
She gave you the
I
answer, I don't
don't
know,
know.
on multiple occasions.
Okay. So you're saying your answer to my questions is you don't know.
Yes,
But you're also testifying that you were told records had to be produced, you were trained that records have to be produced unless they're exempt or confidential. Can you explain the inconsistency there, Ms. Sewell?
Objection to form.
because I don't know what record you're saying is not provided to you. I don't know.
I'm not
There
talking
may
about
be an
inconsistency.
exemption, there may be an exemption of confidentiality, why it was not. I don't know. That's why I'm saying I don't know.
If a record is exempt or confidential, so it's withheld for that reason, does that need to be stated?
If it's
Ms. Sewell, can
exempt,
you please-
yes.
Excuse me?
If it's exempt, yes.
And if it's not exempt or confidential, does it need to be produced?
I don't know.
You don't know. Okay. Ms. Sewell, how many times have you received any type of public records training in your best estimation?
I can't recall.
Do you recall when the last time you received public records training was?
No,
No. Ms. Sewell, due to your training and many years of experience, would it be fair to say that you're an expert on public records?
no,
Is there some part of Public Records Act or Public Records Law you don't understand, Ms. Sewell?
Objection to form.
no.
So you feel that you understand the Public Records Act and law very well, correct?
I understand it. I don't know about very well.
Okay. I'd like to share a video. Second. So I want you to watch this video. This is our interaction on July 19th, 2016. Hi, how are you doing, Ms. Sue? I was wondering if I could personally inspect these records.
I don't have them in my office right now. I have to get them from the staff that's producing the records.
Okay, and I'm a little bit curious here on what these charges are.
Well, I haven't reviewed the invoice.
You haven't reviewed the invoice?
But it is stated here what it is.
Yeah, but with like the legal fees, one, the contract for the legal fees shows that they charge at a rate of $125 an hour, not $204 an hour. And that's only for extraordinary work where they're on a flat rate retainer. So I'm not sure why I'm even paying for legal fees.
Where did you get those numbers?
Oh, I'll be happy to show those to you. Here's the contract that the city has originally with Cooven and Stetson. And this contract was adopted by the city in one of their city council meetings.
To get transferred to the other company.
I'm also curious with the staff charge at $45 an hour. My understanding is I'm supposed to be charged the lowest cost employee.
For anything to do with ITS and that technical assistance, it is $45 an hour. That's the flat rate.
And what is ITS assistance?
That is technology.
Technology?
Yes, it's technology assistance. It's the assistance provided by the ITS department, which gathers all of the emails from everywhere that it belongs in the city.
And it took them 5 hours to find the emails?
It took 5 hours to do the
Okay.
to do the research.
Do you know who would have prepared this?
Prepared what, the
This
invoice?
invoice, yes.
My department prepared the invoice.
It's okay.
But the staff gives us how many hours, at what rate that they did the work at, according to the redaction. For the redaction services for confidential and exempt information, that was given to us by the attorney staff.
Okay, and I'm also curious, because I originally filed this records request on 10/2/2015, and this is 9 months later when they're responding, giving me the invoice. Do we have any reason why they're taking 9 months to respond to this?
I don't have a reason.
There's no reason? It's just an unlawful refusal to,
Excuse me?
an unreasonable delay in time to respond is unlawful. I'm not saying that you broke the law, but it appears that somebody's breaking the law.
It doesn't take 9 months to produce electronic records, okay?
Well, originally they responded back in a month, in a week, and they said it was all attorney-client privilege and wouldn't give it to me. Now they're deciding to give it to me. Do you know who made the
I
decision?
don't know who made that decision, sir.
Okay.
This department processes records that are given to us as the custodian to give to the public. That's what we do.
Okay.
We make no decision on what to give you or what not to give you.
Okay.
Whatever we have, we produce.
Okay. And if I just want to personally inspect the records, can I just do that? Or can you make it available so I can inspect them? Or is there a department I can go to inspect these records?
I would have to check with staff.
Could you do that for me?
Right now,
Or
they're gonna drop everything they're doing and stop for you to review records. You did not make an appointment, sir.
not
It would be-
under law, I don't have to make an appointment to review records. I know you asked me to make an appointment before in the past to review records, but that
We're
isn't.
not, okay, we are required to produce them to a reasonable time. You showed up this afternoon to review records. I have things on my desk I'm working on. Right now, I'm waiting on stuff from the attorney to process. So if you want to review these records with me right now, I can't just stop and drop everything.
Well, I understand you don't have the records right now. I was saying, could you check on if we could get the records, or is there a place I can go to review the records? I understand you can't give me an answer right this
I can
second.
give you an answer as soon as I get the answer, sir.
Okay.
I don't understand why you don't have the records. He was issued an invoice. That means your product is ready, come and pick it up.
No,
He's
it
coming
means-
here today to pick up the records.
Sir, it means that when you have paid the fee for the production, to do the work and not get paid for it, okay?
And get paid
So,
very well
because
for it.
Well, sometimes what happens is we do the work and we get stuck and we don't get paid. So it's a policy decision that once we get paid, we move forward with the production of the records.
And who do I contest this?
That's the fee.
Yes, I think it's an unreasonable and unlawful
Well, I
fee.
think you have aren't you doing something with the court, with a lawsuit or something?
Yeah, I'm trying
That.
to avoid filing more attorneys and putting legal costs on the city taxpayers. If my attorney do something separate, it costs. When the city's found to be not following the law, it costs the taxpayers. It's a burden. And I'm just trying to do whatever I can do to where we can amicably deal with this and where I
We
can
have to
lawfully.
review this with the staff who has done the work and see if they can do anything to help us with this.
Okay.
But
It-
I don't have.
Where in the law does it give the city the right to charge the $45 an hour for ITS?
Because it's a.
Not because, where in the law does it give the city the right to charge that?
Statutes, chapter 119.07.
Okay.
Okay?
Okay. The Supreme Court in the past has ruled that they were only able to charge $35 for attorney reviewing things. So that's okay. I guess I'll be filing another lawsuit, Ms. Sewell. But thank you for your time and your cooperation. We really appreciate it. You have a great day. Well,
Okay, Ms. Sewell. At the end of that video, I walk out. Was that our interaction that day?
Take a minute
Oh, hold a second.
and appreciate these waves. We've definitely got some rollers out here, some chop. Now it's not too crazy today.
Sorry about that. YouTube likes to blow up other videos. Ms. Sewell, was that, to your recollection, was that the end of our interaction as I walked out?
You walked out, yes.
But I didn't come back in that day, did I?
I don't recall.
Okay. Ms. Sewell, when you filed a police report about this interaction, you said that I was aggressive with you. Could you explain, after watching the video, what I did that was aggressive?
Objection to form.
I don't recall when I filed the police report. I'm not sure if it was after this interaction.
It was about a month and a half to 2 months after this interaction, specifically because of this interaction?
Objection to
No.
form.
I don't think so, Mr. McDonough. I believe there were other interactions after that interaction.
You and me have very rarely interacted in your office, Ms. Sewell. Typically, I've dealt with the assistant clerks. Is it your testimony that that was not the interaction for which you filed the police report for?
From my recollection, yes, that is not the interaction. That was not the only interaction.
Okay. I'd like to show another exhibit. We can call this Exhibit 8. Do you see this email, Ms. Sewell?
Barely, but yes.
I'll highlight. Can you oops, highlight more than I wanted? Sorry. Can you read the date of this email?
I don't, oh, July 21st, 2016.
Okay. And can you read the highlighted section of the
I
email?
apologize if there was a miscommunication during our conversation earlier this week. I was caught off guard and flustered by being videotaped and what I thought was your aggressive tone.
Okay. That video we just watched was from July 19th, 2016. This email is from July 21st, 2016, 2 days later. Would you agree that this email is in response to that interaction we had?
Yes,
Okay. So Ms. Sewell, you stated there in your email that I was aggressive. After watching the video, can you state how I was aggressive?
there was somebody else with you that was aggressive.
Was I aggressive?
Somewhat.
How was I aggressive, Ms. Sewell?
Because I tried to explain to you the process for how the public records is processed, and you did not, you kept complaining that it was unlawful.
Is that aggressive or is that assertive?
It depends.
Objection to form.
It's your opinion and my opinion. You're asking my opinion.
Were the clothes I wearing aggressive, Ms. Sewell?
I don't know.
Was me providing you documents showing you where I was coming up with my statements from, was that aggressive, Ms. Sewell?
The videotaping I found aggressive.
You found the videotaping aggressive.
Yes. And the person that was behind you with their comments.
Okay. Are you aware that I have a First Amendment right to record public officials?
No,
Okay. Do you believe that people exercising their First Amendment rights is aggressive?
no,
Objection to form.
No. But me exercising my First Amendment rights was.
I did not know you were exercising your First Amendment rights.
What was aggressive about me recording it, Ms. Sewell?
I answered you. I found it aggressive.
What about it was aggressive?
I found it aggressive.
Did it frighten you, Ms. Sewell, that I was recording?
I was taken off guard.
Did you have any fear for your life or your safety, Ms. Sewell? Would you like me to restate the question?
I found what you was doing to be aggressive.
Did you fear for your life or safety, Ms. Sewell?
Safety, yes.
And why would you fear for your safety, Ms. Sewell?
The way you all approached the window.
Did we try to come through the window?
No, you didn't try to come through the window.
You opened up the window and you approached the window, correct?
Yes,
Would most people consider that an invitation to walk over to have a discussion with you?
Objection to form.
I don't know what you took it as.
I mean, you opened the window.
I cannot testify to your mindset. I'm telling you mine.
When you stepped to the window and opened it, were you inviting me to have a discussion with you, Ms. Sewell?
No, I was just going to give you information.
Okay. And the fact that I walked over to receive your information, that was aggressive?
I didn't say that, but you pointed a camera right into my face. That was aggressive. And the
Okay.
person behind you that was badgering me was also aggressive. And I believe that was Mr. Oki.
That was Mr. Oki. Yes, it was.
Mhm. Which you two have teamed up against me in the past.
Could you explain how we've teamed up against you in the past, Ms. Sewell?
Yeah, you served me court papers in front of the council and everybody, the public, in a council meeting. You remember that?
Was there something improper about that, Ms. Sewell?
It was very embarrassing. Would you like that to be done to you or your family? No.
Oh, the people you work with have done
Any
way
other-
worse than me, Ms. Sewell.
Oh, no, I have not.
The people you work with have done way worse than me, Ms. Sewell.
I have not. I have not done anything to you.
You filed a police report against me, Ms. Sewell.
Yes, because I felt like I had grounds to at that time.
Ms.
When
Sewell, in
you
your
guys
police,
show up in here with knives and all kinds of things, yes, we've had a reason to do that.
what was it? I came in your office with a knife?
I did not say you. I said Mr. Oki did. You stopped
Mr. Oki came
my
into your
word.
office with a knife.
Yes, he did. In the lobby and flipped it open at my staff in the same window. So
Was
we
I
have-
there?
We have, no, you were not there at that time, but we do have concerns about you guys coming here
You
because of your
guys.
past behavior. Yes, you guys, you and Mr. Oki, both.
What is my past behavior that concerns you, Ms. Sewell?
Mr. McDonough, you know what has transpired. I am not going to go over this today.
Oh.
You know what has transpired in this office and in the council chambers. And we will not go over this today.
Sylvia, will you note that the witness is refusing to answer the question? Ms. Sewell, in your police report, you stated that you were afraid to walk to your car because I knew your vehicle and you were concerned that I would follow you home and harm you.
I said I was
Objection to
afraid to
form.
get to, I was afraid to go out into the parking lot in the dark and that you may follow me. Yes, I did say that. I didn't say you was going to follow me home and harm me. I don't remember that. I don't recall that.
Okay. Well, you testified a little bit earlier today that you're not afraid of me. And I've never placed you in fear. If you're not
You're
afraid
going
of
back
me,
over the police report. If you want the mindset, but the police report, I'm giving you the mindset. Today, I feel differently. And I
Okay.
explained that also. Why?
you also stated at some point that I brought my young daughters in to distract your staff so I could harm you. Could you explain that a little bit, Ms. Sewell?
Objection to form.
That was already in the police report, sir. I'm not going over that today. There's no reason why.
There's no reason why you thought I brought my daughters to distract your staff?
I am not going over that today. That has already been addressed in another deposition.
Sylvia, will you go ahead and certify all the questions about the police report? Ms. Sewell's not answering them. I need to go back in front of the judge, and we're gonna have to come back here if the judge says you need to answer that. And that's probably
You
gonna,
already have her sworn testimony regarding the police report.
Not in this case, and you're the one who made it an issue that I can't use discovery for other cases to combine. So we're going to go for it again, Mr. Zeskine. Shouldn't have made it an issue if you don't want to have to redo it. Sylvia, you did note that I have a whole list of questions about the police report, and Ms. Sewell's refusing to answer it. So I'm not going to waste any more time today on that. We'll just file a motion to compel with the court. Ms. Sewell, no disrespect to you, but just to be clear, you have not taken any alcohol, medication, or drugs which will prevent you from being able to understand and truthfully answer my questions today, have you?
No, I'm not an alcoholic. And I'm not a drug addict.
And are you on any medication from your doctor?
Of course, I'm on medications, but none of them that would prohibit me from answering your questions.
Okay, that was my question, Ms. Sewell. And you weren't taking any drugs, alcohol, or medication around the time that my request was filed that would prohibit you from properly responding to it. Is that correct?
No.
Ms. Sewell, I don't think you're an alcoholic or a drug addict. I need to get this confirmed because it doesn't appear that you can answer my questions. And I want to make sure you don't later come up and say that you were drunk or high and you didn't understand it. We're just setting the ground, a baseline here.
Objection to that form.
No, I'm not taking any drugs or alcohol.
That's fine, Ms. Sewell. I didn't think you would. You were. It was just something I have to clarify because your questions are.
My questions, I think.
I mean,
you were
your
asking the
responses to my questions, your answers are a little bit hard to believe, Ms. Sewell.
Well, that's your problem. That's the truth.
That's my problem.
Unfortunately.
It's going to be the city's problem when they again lose another lawsuit because of your actions, Ms. Sewell.
I've done nothing. I
Objection.
don't, you're asking me questions I don't know answers for, and you keep repeating the same questions over and over. So
All right, Elizabeth, don't engage
I
any
don't-
further in the back and
I
forth.
don't keep repeating
not
the
a
same
question,
question
okay.
over and over. I ask different questions. And that's why I'm wondering if you're on drugs or alcohol, Ms. Sewell, because apparently you don't understand the nuance differences between my questions.
oh,
All right, now you're
okay.
just
And
probing
now
and
you have gone
attacking
after me
the witness.
personally. Now you've gone after me personally. Okay, and that's the kind of behavior you have. And that's what I'm talking about.
Ms. Sewell, I'm explaining the fact that you continue to not answer my questions. You make the same answer to 12 different questions and you say they're the same question. They're not. I'm wondering why you don't understand the difference between these questions. When we started off, the ground rules I laid was if you did not understand the question, to let me know and I would repeat it for you. Apparently, it appears, in my opinion, that you didn't understand many of the questions, and I'm just wondering why you can't answer these questions.
And so I'm on drugs and alcohol. Okay, gotcha.
I don't know if you're on drugs or alcohol.
That's
I'm
what
trying
you're
to
saying.
find out if you are. And if you're not, I take your testimony at face value that you're not on drugs or alcohol, Ms. Sewell. Do you have any other explanation for why you haven't been able to understand my questions today, if it's not drugs or alcohol?
Objection to form. She didn't say she didn't understand your question.
I answered what I understood.
Okay, well, since you're not going to allow me to answer the questions about the police report and a few other things, I'm going to go ahead and call it for today, and I'll file a motion to compel with the court and see if the judge wants you to sit down and answer those. Do you have any questions, Mr. Zeskine?
No.
Okay, thank you for your time, Ms. Sewell.
The witness will read.
Okay,
And so I'll order the transcript.
okay, thank you.
Thank you, Sylvia.
All right, have a good day, everybody.
You too. Thank you, Sylvia.
Bye-bye.